All right, welcome to this month's Wednesday webinar. I'm Shannon Dill. I'm with University of Maryland Extension, and I am happy to introduce Paul Goeringer. He's a senior faculty specialist with Extension, and his favorite topic, estate planning. So, Paul, I'll turn it over to you.
Okay. Thank you, Shannon. Happy to be here today to talk about estate planning with y'all. So, look at my slide deck so it will actually move up. I'm in the Department of Ag and Resource Economics. I'm also a part of the Ag Law Education Initiative. Here's some of our information. We're a collaboration between College Park, where I'm located at the School of Law in Baltimore at UMB, and then UMES through the School of Ag and Natural Sciences. Our website, everything there. We're funded through University of Maryland in the state. There's more information there about that. None of this is legal advice. I'm glad you're all good with it. We're going to keep going because this is being recorded. And I should say, if you're in Delaware, I think I can remember parts of the Delaware information, but it's mainly Maryland focused on this one. I forgot to add in the Delaware stuff actually this morning. So my first question is often in this process is, where are you at in the estate planning process? You know, have you started? Have you not started? Have you thought about it? Where are you at in this process? So take a minute and think about it. And many of you might be lost and need a map to show you where you're at this point. So I often go in here and remind you. You're right there in the galaxy. We're all in this same problem together. Things can happen. So things we need to think about in this process as we go through. So the goal is to get you, as you start thinking about this, where you want to go. And as I often start this off with, you're going to have to think about how you're going to communicate with family members and other heirs that will potentially have to be a part of this situation. And at the same time, if we're dealing with a farm, we're really going to need to think about what the business plan is, especially if we're bringing another generation in. If we're passing it on to another generation, we're not going to have two generations working together. We may be able to continue doing stuff the way we're doing it and it'll work out perfectly, but we need to make sure that there's a plan for, if we're bringing another party in, how is the farm going to support that other party? And then often at the same time, we need to think about what that estate plan is going to look like in the end. That estate plan may be different depending on each family. It's also going to have to take into account how we're going to pass on a business in some way to potentially just one heir, but also take care of all the other heirs within the family that need to be taken care of. And by heirs, I typically mean your direct descendants, your children. If there aren't children, potentially nieces, nephews, other family members somewhere in there, and it may be moving outside the family if we can't do this. So how do we develop an estate plan? Actually, I'm gonna make y'all smaller so I can see more of my screen. Okay, so 46% of most recently surveyed people, and this would have been a 2022 survey that was published in 2023. 46% of those 55 or older do not have an estate plan. I believe the same survey, I believe it's in the same survey, found 66% of all Americans do have an estate plan or do not have an estate plan. 34% of Americans do have a estate plan. So if you don't currently on this webinar have an estate plan, congratulations, you're in the majority. Unless you're 55 or older, then you're in the minority. And these are often set up the way we would think based off survey results, because we would think as you're getting into your 50s, this is a topic you're actually thinking about. So what do we need to think about when we develop the estate plan? Well, first off, we may have minor children that are involved. We may be the person taking care of minor children. Over the past number of years, not only in Maryland, but other states I've lived in, I know people who are raising their grandkids and they've adopted their grandkids for a number of various reasons over time. So we may have older generation with an adopted grandchild who needs to figure out who's going to take care of that child if something happens, and who that guardian's going to be if we run into this. We may have to figure out who beneficiaries are going to be. And this would be beneficiaries on payable death bank accounts, other similar type payable on death accounts, retirement benefits potentially, life insurance, other things of that nature where we can designate who gets that, and things we don't then have to think about putting into the will or the trust that we're going to talk about. The other thing we have to think about is powers of attorney. And we're always going to do more or less two of these. We're going to have one that's a business power of attorney that's going to handle business affairs, paying your bills, making sure any obligations you have to meet are taken care of, managing assets in a way to where we continue to make them profitable if needed. Other things that may come up that are just much more related to normal everyday things we might have to take care of if we're incapacitated for a long period of time. The other one we need to think about is our health care and who's going to make those health care decisions for us if something happens. That may be a child, it may not be a child, it may be a grandchild, it may be whoever you trust the most with your health care. The other thing we're going to deal with is an advanced healthcare directive. And if this was live and in person, I often ask people to raise their hands if they've ever had to do one of these documents before, because I put them together as an attorney and they're not fun to put together. It is laid out in statute what it needs to look like and lays out all the ways you could potentially be incapacitated or put on life support. And you have to think about, do I want to be on life support or giving life saving care at that point, or do I want something else? And you have to check a box. It seems kind of impersonal as you're doing it, and people don't like thinking about it, but it's things you need to do. We'll talk about that more here in a minute. Within all this, there's probably going to be a will or the document that lays out how your assets are going to be distributed. Potentially a trust. Trusts just vary depending on size of estate, goals of the estate as to whether or not we're going to do them. Some potential tax benefits in doing them. Other benefits may arise from them as well. And then finally, we may think about life insurance and all of this as well. So you have a chat box. Tell me, what do all these famous people have in common? And for those that don't know, starting at the top, my left, I'm assuming that's still your left, we have Sonny Bono, Prince, Aretha Franklin, Martin Luther King Jr., the odd one, Howard Hughes, Amy Winehouse, and Chadwick Boseman. Who has a thought that they want to feel brave enough to put in the chat box as to what happened? Oh, and I see somebody is raising their hand, and I do not know what to do with that. But if you want to put it in the chat box,
they died without a will.
They died without a will. They died without a will. Now, mind you, a few of them, he got a concussion more or less and died, drug overdoses, assassinated. But these three, if we think about it, we have Aretha Franklin, Howard Hughes, and Chadwick Boseman. These two were older when they passed away. He was told he had terminal cancer. So even then, we didn't even think about doing it at that case. So there's some opportunities where we may not be thinking about it in some people's cases. And in other cases, we may know what we're going to happen. In one case, I know within like Aretha Franklin's case, she just had a distrust of most lawyers. And if you've never heard the stories of how she got paid and the fact that she kept her purse with her at all times, she had a distrust of she had been cheated numerous times. So there's some history as to why she may have not done that either. But others, it's potentially out there. So yeah, even famous people die without a will. So if you die without a will, the state has a plan for you. It's called intestate law. So this is state law. They govern how your property will be distributed. Intestate just means you died without a will. And there's a rationale for why I have Snoop Dogg on the screen here in a minute. Intestate law, and I'll talk about that after I get through this part. Intestate law is designed to divide your property up among your family members. Typically, we look at who are your closest family members. You might have be in the midst of going through a divorce. You may have on paper disowned children. In the eyes of the law, they don't care. In the eyes of the law, they look at what was the relationship, at least legally at that point, with each of these parties. So if it's a surviving spouse, even if we're going through a divorce, that person is still treated as a surviving spouse until the divorce is decreed. Children are still treated as potential heirs, regardless of their relationship with the person that passed away. So the ideas are, if you didn't want them to have it, you should have wrote a will, because that's the easiest way around this. So the state system typically has a system in place to do this. Now, the reason I have Snoop Dogg up there, so a few years ago, I still find this to be one of the more odder stories that was in the news one day. Snoop Dogg talked about how he's worth millions of dollars. He has no plan to have an estate plan. He plans to pass away without a will, be reincarnated as a butterfly, and watch the fight between his family over his estate. So within all of this, there is a way to do this. You can take Snoop Dogg's method, which is kind of a weird method, or you can actually work on developing a will. So who can make a will? And I often just appreciate this quote from the Arkansas State Supreme Court. You don't have to be a genius, a college graduate, a high school graduate, or ever attended grade school to make a will. Anyone can make it, as long as they are of sound mind and over 18 years old in most states. Doesn't matter. So one tool we should all think about having. So at this point, I often point out, if we're thinking about this, and as we progress through life, what happens to us as we progress through life, potentially with sound-mindedness? We potentially have moments of where we're lucid and we're very sound mind, and we potentially do not. We all have probably dealt with family members who have gotten older and had dementia, Alzheimer's, something that impacts their ability to remember either all the time or for brief periods of time, just depending on how that disease has progressed. If we're dealing with a person that's reached that point, they're probably no longer able to make a will or do any of the other estate planning tools that we really need to do. So this is really important to do before we get to the point that we should have done something years ago. If this was a tax presentation too, and I don't do tax law, there'd also be talks about why you need to do this earlier on too, to set stuff up in ways that help protect assets, as we potentially may have to go into long-term health care to protect them from Medicare and Medicaid issues that may arise as you get older. The other thing I often point out to people too is, if we do these when they're older and the parent or whoever, the aging family member, is relying on one younger family member to take them places, often, maybe grocery shopping, to the doctor, a lawyer if they need to visit one to make a will. If we're seeing that and we're having that happen as the attorney, we're often only going to have the person come into the room that needs to make the will. The person leading them or taking them around will be asked to stay in a room. And more than likely, that person is about to get put on camera for a while to talk about things and make sure that it is very clear on the record that they are of sound mind. So if anything happens down the road, we have some evidence that this person was very sound mind when they came in, and the other person was not prompting them on any answers, because that's often a concern. We often see court cases where people have been, potentially mistreated in the estate planning process by a family member who has, they rely on more. I often bring this up just to make people aware of it. There's often what is known as a holographic will. The picture on the right is a holographic will. It is one that is not properly witnessed. Typically within most states, we need 2 disinterested witnesses. What does a disinterested witness mean? That means they don't collect anything under the will. Typically, when you're doing this with an attorney, the attorney will have people in the room who work in the law firm, and they will help provide that. Holographic wills are written entirely in the handwriting of the testator or the person who is the will is written for, the deceased person, and they have to be signed at the bottom. If you see this on the right, it is written entirely in the handwriting of Brock Drummond and signed and dated at the bottom. Even though I'm from Oklahoma, I did not pick this image just because it was from Oklahoma. It was the only really good example I could show you where you could actually read what the person wrote. In Maryland, in Delaware, they're a little more valid, and I can get the Delaware people the information if they want it. In Maryland, they are only valid if they are made by a member of the armed forces and signed while they are overseas in a war zone, typically, and they are void 1 year after discharge. Why might we allow that? Well, if you're in the armed forces and you're overseas, more than likely you're in a war zone, sometimes not. And you're typically potentially thinking about what could happen if you pass away. And we want to provide you with the opportunity within the eyes of the law to make this will. All the rest of us, you have to go through an attorney typically to do this. I point this out because some people are what one of my friends that teaches on the same subject likes to point out are what we like to call control enthusiasts. They like to control everything throughout while they're alive, and they cannot give up control. So you can change your will if you want to at any point. You typically do that by drafting what is known as a codicil to the will, or it's just a document that amends the will. The will is still valid, but we add in amendments to it, or we can just draft a new will. The reason I point this out is at all points, you still have to go through the process to make a new will. You cannot write in the margins to change any of this document. You can't cross people out. You can't do anything like that. If someone dies, you have to change it. You have to go through and change the will through the proper methods. I often point this out. The reason we make you go through this whole process is the one person we need in the courtroom to tell us that this is what you wanted to do cannot come talk to us at that point because they have passed away. They are no longer able to tell us what they want. So we hold this to a higher standard than we do for contracts or leases, because the party that can help us best understand it is no longer around to help us understand it. So we don't allow margin notes. We don't allow anything. It has to go through the proper process. We are all going to have property potentially outside the will. We're going to have life insurance policies. Those have already had a beneficiary selected. Remember at the start where I told you selected beneficiaries for certain things? Those pass outside the will. They go to whoever is already listed in it. You cannot change who they go to in the will. You have to go to the actual thing itself and change that within it. So if someone passes away, you need to change beneficiaries. Payable on death accounts, they go to who you select as the beneficiary. Joint bank accounts, there's already a person on there. Real property that's held as joint tenants with rights of survivorship in all states, and then specifically in Maryland, if you have real property that is tenancy by the entirety, which is exactly like joint tenants with rights of survivorship, except it's only when you're married you get it. You have property titled in that way. That's all going to go to whoever the surviving joint tenants are, or the surviving spouse in the case of the other property. Trusts. They're not like everybody. And I missed this slide. I got everything, the year updated on everything but this slide. I'll fix that and send it to Shannon later today. Unlike wills, trusts are an important, not potentially an estate planning tool that folks can use. Typically, we're going to consider using them when you're approaching either federal or state estate tax limits. For this year, 2023, disregard this 2019. This number is correct for 2023, and this number is correct for a couple. It's 12.92 million. IRS should be releasing the numbers for next year. This is tagged to inflation. So it'll probably be pushing over 13 million by next year and 26 million for a couple. Those with children or disabled family members who they need to care for, potentially after their deaths, you would want to have a trust within that. And then family members who can no longer manage their own assets. So typically if we have concerns of Alzheimer's, dementia, other illnesses that could come up as we age, we may, or things that can happen to us when we're young to where we may not be able to manage our own affairs as we get older. We might want to consider this as well. So then they can take care. Then we have somebody that can manage the assets and manage the things that need to be managed in order to take care of this person as they age. We can create these in a will. They're called the testamentary trust. This is typically one we set up potentially that comes to life with a parent passing away to take care of a minor child or a disabled child or other family members we might be relying upon to take care of. A living trust. This is the one a lot of folks use in estate planning. This is created during the trustor's life or the person the living trust is set up for. And they continue after the death of that individual. We do this in many cases to avoid probate. Folks do not want their property going through probate. I think I have a slide here in a minute. I'll talk about that. So typically while you're alive and they are set up, they are revocable. You can change them, dissolve them, get rid of them, do whatever while you're alive. Once you pass away, they become irrevocable and there is no power really to change the trust. We're just working on either managing assets until it dissolves or something else at that point. So why might we consider living trust? Well, we want to avoid probate costs. Probate costs, I believe in most states, are typically 1 to 2% of the value of the estate, and this is just money you pay into the court. They allow for transfer of property in different states. In this Maryland, Delaware, Pennsylvania, Virginia, we may see people, West Virginia, we may see folks that are farming across state lines, own property in multiple states. This is a really easy way to get around probate and not have to probate in each state we own property in. This way we just transfer the property through the trust document. It allows for better management of assets if you become incapacitated because we already have a trust set up to manage all that for you. And it passes property on much quicker than the probate process. So reasons to not consider them: they're expensive to set up. There's a lawyer involved in this. None of this you're going to do on your own. There are online services that folks may consider too. I'm not going to talk about those because, and then the expenses can potentially outweigh the benefits. So here's where I'll explain some of the differences between the two, why you might want to. I'll just bring up all the things. Like I said before, if you're a control enthusiast with a will, you get to control everything until the death. You get to direct who gets property. You're going to select the executor of your estate, who's ever going to take the will through probate, guardians if they're needed. And once the property is distributed, we no longer have to worry about it. You have to probate it. That is a con. Easily contested. If folks have, disowned family members or family members they're no longer communicating with, we try to cut them out. They can still sometimes contest the will even with a no contest clause because there are ways courts still allow contesting a will to take place without that. And when we contest a will, we're typically contesting the validity of the will, that it's actually what you wanted. Probate takes time and it's a public process. Your will is put on file. Anyone can go to the courthouse to review this document. I've told this story a few times. I often did not know anyone who ever took their time to look at a will and figure out, what was going on until one of my parents' neighbors passed away who had some money, but no children. And everyone in that little community wanted to know where the property was going and who was getting it. So multiple people went to the courthouse just to get a copy of the will once it was filed. So I was like, did not know that was actually something people cared about until that moment. They're very state specific. If we put one together and we have property in multiple states, we need to make sure it works within multiple states. Now, typically when you're working with attorneys on this, they will know that you have property in multiple states and the will be written in a way to work in all those states where it will have to be probated in. Cons of these and pros of living trusts: we don't have to go through probate anymore. None of it's public because it's a private document between only the parties a part of the trust in the end. It's very difficult to contest. If they're not a part of the trust, they can't contest it. Guardians don't need to hold assets for minors and manage them for them because the trust can do that in that case. You potentially have to pay trustee fees. If a family member is not willing to do it for no fee, we may have to go to a bank, or we may just want to go to a bank or another financial manager to do this, just so we don't have infighting among children. And it adds a little bit of complexity to it. That might be a con for some folks. We still have to coordinate it with other estate planning tools because we're still gonna have a will. We'll have what's known as a pour over will. These are wills that basically read everything we forgot to put in the trust and title in the trust passes according to the terms of the trust. And it's typically just a catch-all document in case we missed anything, putting it in the trust early on, or you forgot to title something within the trust. The other things we're going to think about are a durable power of attorney with all this, because once you're in the attorney's office, this is a process we go through to look at not only a will or a trust or whatever else we need to manage the assets to do whatever the plan is. But we also need to take care of other things that can arise if you get hurt. So this is something where someone will make business and financial decisions for you if you become incapacitated. That power lasts until it's either revoked, you come out of whatever happens to you, or you pass away. Healthcare proxy, same exact idea. This person makes decisions for you related to your healthcare until you have the ability to either make those decisions for you, or a doctor agrees you can make those decisions. I point this out, this is really no longer the case. If they aren't limited now, they typically are, because we have other instruments that allow for this to happen. But older ones may still be in this ways to where they were written in such a way end of life care decisions may be included in them. That is no longer really the case in most states. That gets us to the last thing we'll probably have you think about doing while you're in there. It's called the living will, or that advanced healthcare directive that I talked about earlier. It is a specific set of instructions given out by you when you can no longer make those decisions. Typically, it's what type of treatment do you want in certain situations when you're incapacitated and may need to be giving life-sustaining either aid or other things related to keeping you alive in long-term situations. Why do we want to do this? Well, A, we take the burden off the family when we do this. You've already made the decision. And as I keep pointing out, many of us are control enthusiasts. So now we can at least specify what we want, at least what we think we want in that moment. We were able to make a decision at that time. We may make a different decision, but we've made a decision at that point. Family members don't have to think about it. They may not like the decision that the parent or other family member made, but they at least know the family member made it. And you get to make those decisions again when you can't make them. So let's talk about tax considerations. We already talked about what the federal estate tax exemption is. And as I told you, I had the number right. I just had the year wrong. I need to change that and we'll catch it. I always forget that year's in there twice. So it's 12.92 million for this year. Like I said, it'll probably be close to over 13 million next year. It'll be over 26 million next year for a couple. The thing to point out to everybody is we are on the last 3 years of these current levels. This is a part of the large tax bill that was passed under the previous administration. And based on the way it was passed, it can only be for a limited amount of time. And it sunsets in 2026. We will revert back to prior law at that point. In prior law, I believe we were pegged to inflation starting at the 5 million level. My guess is if we actually revert to that, we would be in the neighborhood of probably 7 to 8 million at that point for estate taxes. And yes, the slides will be available. I just saw that one. Yeah, so that's something to keep in mind in all of this as we move forward. So with federal estate taxes, the other thing is you have this idea of portability. If you are married, once one of the spouses passes away first, any property that was the predeceasing spouse's property can pass to the surviving spouse tax-free. Now, for years, this left this unused federal estate tax exemption, also known as the unified credit, that I'll talk more about here in a minute when it comes to gift taxing. That unused portion just went unused. Congress allowed for this idea of portability, which is we allow that unused portion to be used by a surviving spouse now. So go back a slide. So now if you pass away or a spouse passes away this year, everything passes to the surviving spouse. That predeceasing spouse out here somewhere had 12.92 million in federal estate tax exemption. So that's kind of held out here. Whenever the surviving spouse passes away, we have that 12.92 over here to use, plus whatever the estate tax exemption was used available in the year the surviving spouse passes away. So we can effectively get the doubling without having to do anything in that. But as I point out, you usually have to file appropriate tax forms. And here's the biggest thing we always have to point out to people again. You cannot get remarried. If you get remarried, that goes away. So if that's a part of estate tax planning in the estate plan, we need to keep that in mind. In 2019 or 2018, we were supposed to be pegged to the federal estate tax exemption in Maryland. We were not, because it effectively doubled and the state did not want to do that. So they capped it at 5 million, but didn't index it to inflation. So currently in the state of Maryland, you get $5 million, but the surviving spouse has portability. So the same idea in the federal system, there's effectively 10 million in estate tax exemption to use for a couple in the state. Other strategies to utilize as well. So there is a special exemption for just ag property in the state. You get 5 million, the 5 million in ag property exempt, but you have to agree to keep it in ag for 10 years. And unlike some of the federal tax valuation rules that exist for agriculture, this does not have to be farmed by a family or farmed by the person taking it on. It can be used by anyone in ag as long as you keep it in ag. Other things we can do with all this, we can utilize the gift tax. This year it is $17,000 to any individual. For a couple, you could give $34,000 to any individual. If you give over that amount, it just reduces down that federal estate tax exemption. Like I said before, that federal estate tax exemption is actually known as a unified credit that we all get. And that just shrinks as we start gifting over that limit. So in a lot of cases, we don't gift over that limit. We get close to it, but we don't. There are other things we can do too, and we'll talk more about strategy here in a little bit. So what are some other issues we have to keep in mind? If we're dealing with a farm and passing on a farm business, how do we handle the issue of, city kid versus farm kid? And what do I mean by that? Well, we had one kid that stayed on the farm, might have foregone going to get higher ed. We have another kid who goes to college, gets a degree, maybe gets another degree, maybe gets another degree, maybe gets another degree, and ends up working, somewhere that's not on the farm. How do we handle that situation to where now we have one kid on the farm, one kid not? How do we manage that in a way to where we're not really worried about it being equal, but we're more concerned about it being equitable? A lot of families are always concerned about dividing assets equally. In this case, we may not be concerned about passing assets on equally. We're going to worry more about equitability because we want the kid on the farm to be able to survive the farm business. So business entities, some ways we could do this. We could put the farm business in an entity. It's owned by the heirs, but the control of the entire entity, all the decision-making authority relies on the on-farm successor. Those off-farm heirs just get participation. Use of business entities can help facilitate this. So we could look at LLCs, corporations in some way. One thing I'll say about this too is, and especially if we have families still involved in this, like parents, the other thing we can do with this is we can gradually pass on the percentage of control to that on-farm heir and utilize that against the gift tax. And we can probably give them, as long as they're never getting the 50% control, or 51%, excuse me, it's 51%. As long as they never get to 51%, there's some ways within IRS rules that you can sort of discount the percentage given to where you might be giving them close to $17,000, but because they're getting a minority interest in the business, we can gift that down lower. I'm not a tax professional, so you should talk to a tax professional about those strategies. Other things we can do is look at conservation easements where they're available. That may be a way to equalize excuse me, payments and how we're distributing assets between on-farm and off-farm heirs. They can potentially get some cash into where we can kind of equalize things out. One thing we often talk about with all this is this is a important thing for a family to start doing early on when they have kids, especially if a business is involved. Because if we do it early on, we can potentially go out and set up investment funds with a small amount of money that can be managed over time to eventually grow to where we can then have cash on hand to sort of equalize payments between the heirs to where, yeah, one heir is getting the whole farmland and everything associated with it, but we have this cash pool over here to kind of help equalize stuff out. So we feel like we're being equal. At no point did any gift in this story or in this presentation make sense, except for this one from Monty Python and the Search for the Holy Grail. For those that have seen this fine classic, there's a scene where the lord of the manor looks at his son and tells him, "Lad, all the must one day will be yours," as the son does not want to get married. That's more or less the idea of sweat equity. Somebody tells you someday all this will be yours, but because we're not in England where we have nobility and people, that stuff's automatically passed on by bloodlines, we're here. That doesn't work that well, and we actually have to have all this created into some sort of estate plan to work. I've been at Maryland for 11 years now, and we've had this happen over time where I've had people call me and say, hey, I was told I was going to get this, but then I didn't get it. And I did all this work. What do I do? And I'm like, it's nothing you can do. You can't do anything. None of this is enforceable. So we really want to see this laid out with formalized agreements, stuff set up in a way to handle that and make it much more enforceable down the road. I believe I cut out all the sound effects on this. Yeah. So what happens if an heir gets married during the implementation of this plan? We really do have to start thinking about prenuptial agreements. They're not just for the rich, as I often like to point out. They're utilized by a lot of families, farm families, especially with businesses, to where everything is laid out, and our goal is to make sure this business stays within the family. And an heir getting married kind of throws that off in some ways. So we want to make it clear that the spouse coming in has no claim if there's a divorce. Yes, and it can also make people mad when they're presented with that. The other reason we want to do this is with complex families. And as I always point out, all families are complex, but some are more complex than others. This is where we have potentially a husband, wife that have children from previous marriages and no plans to have additional children. We see this a lot in the real world, and we see it a lot in various families. As I often point out, we also have the Brady Bunch. The Brady Bunch is the best example of a complex family. We want to ensure that family members get family assets. So everything's going to the correct family members. And I've seen these done in this situation. It basically says, you know, husband and wife come into the marriage, no plans to have children. They may be older, unable to have children at that point. And we just basically say everything that wife brought in prior to the marriage goes to her children. Everything husband brought in prior to the marriage goes to his children. That's how it works. And they're really easy to do. At all points, when we get done with this, we are not done. We got all this stuff done at this point. We're not done. How many people have ever created a perfect plan in their lives? I'll pause for none of you to raise your hands, because we're human and none of us create perfect plans. And I'm sure you're sitting there going, but Paul, I didn't know. You didn't. No. So why might we want to consider revising the plan? Well, we may have a birth. We may have a death. We may have a marriage. We may have a divorce. Somebody might get disabled. Major acquisition, major disposition, major legal change, or we just want to do this on a regular basis. We want to regularly check in with everybody and just say, hey, is it working out for you? What's going on? How are things happening for you? Like I always point out, if there's a change in estate tax in 2026, people are going to have to go look at how do we change a lot of these plans. When Maryland greatly expanded the estate tax exemption a few years ago, right as I was getting here, so probably about 10 years ago, you could change a lot of these plans that families had set up for farms because now the biggest set of assets was gone, or the biggest hurdle to passing these assets on was gone. So you could manage these with less complexity than you had been able to in the past. And then what happens if the successor passes away? You know, what do you do? What if they don't want to farm anymore? What do you do? I've seen a bunch of stories here lately in I think the ag publishing companies, Farm Press, within their regional farm press. I saw one the other day in I think it was Southeast Farm Press, or I think it was Southeast, or maybe it was one of the newspaper or television stations, and somebody shared it on social media. But it was looking at the fact that there are cotton farmers in West Texas who are looking at retiring and having no on-farm successors. So how are they looking at passing this on to neighbors or other people to manage and still keep it in ag, but also take care of their heirs all at the same time? So wrap up. All of this will require communication. I didn't talk about that a lot, but you're going to have to talk to your family. And the reason we bring up all the tools is you're going to have to go through and kind of figure out what the goals are with this situation and what you want to do. if you do that and you can figure that out, we can figure out what tools you need to use to achieve that goal. And it makes everything more better in the long run. And then in the end, yeah, you all have to go talk to your families before you do this. We used to do this in a bubble to where, parents would go in, write a will, and then kids would never figure out what happened until parents passed away. This way, probably many people on this call may have found out how assets were being distributed. That does not work. At times, it creates sometimes ill will to where families do not talk to each other anymore because someone thinks they should have gotten something that they didn't get. This way, if the parents talk to the kids ahead of time and we all talk about how things are going to be divided up, it's much clearer. It's much easier for everyone to understand. And if a child's going to get mad over being cut out of something, they at least have the opportunity to yell at you while you're alive or talk strongly to you with, loud words. However you want to do it, that's an available thing at that point to where we can work that out and handle that a lot more cleanly than them getting mad at a brother or sister or whoever down the road for getting something they thought they were entitled to. All of this is being funded potentially through the Northeast Risk Management Education Center as a grant I have there. We have an online course that I can send folks a link to do ag sort of basic legal stuff. And this is one of the topics that was included in it. And I didn't catch it. I actually included the slides at the end. agrisk.umd.edu is my blog. You can find that information there. You can also find how to register for the class that I just talked about. It's under funded projects on that website. It's also on the UME website. I'm also a part of this where we talk about Southern Ag Today, where we do policy, trade, ag law, farm management, row crops, livestock, all sorts of daily stuff. If any of you follow Farm Doc Daily, this is just another version of it, but the posts are much shorter and much more focused, sometimes on issues that folks in this area deal with. So what questions do folks have? And I'm going to stop sharing my screen. And so I can see the chat boxes here. And yes, there will be a recording available too, I believe. Shannon, I believe that's on the Women in Ag YouTube page, if I remember correctly. What other questions do folks have? There's a lot of information to cover in 50 minutes, more or less. And none of you probably heard the construction that was going on outside my window as I was talking, and it was throwing me off at times.